OCASI operates. This land on which OCASI operates and where today we are hosting this virtual event is part of the Dish with One Spoon Treaty, an agreement between the Anishinaabe, Haudenosaunee, and allied nations to share and care for the resources around the great traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. Today, this meeting place is still home to many Indigenous people from across Turtle Island. I would also like to invite everyone here today to reflect not only on the land you are on currently, but what circumstances and forces may have brought you here. For myself, I was born and raised on the unceded territories of the Coast Salish people, which includes the Tsawwassen, Stalo, Kwantlen, Semanis, Musqueam, and is also called Vancouver. I'm born to parents who immigrated from Punjab, a region with long-standing links to Canada through British colonialism. Many Punjabis were displaced from their land because of British colonial policies and first arrived on the territories of the Coast Salish peoples as labor, predominantly in the emerging forestry industry to further the settler colonial project of Canada. These early and mainly Punjabi Sikh arrivants referred to the Coast Salish people as Tayake, the Punjabi word meaning our elder cousins, expressing a kinship and respect for whose home they arrived in. I hold this legacy close, and I hope to restore that sense of kinship and respect in the work that I do, including here at OCASI. And again, I invite you all to reflect on your own personal arrival to this land. Now it's my great pleasure to introduce our presenters, both from the South Asian Legal Clinic of Ontario, SALCO. OCASI has collaborated with SALCO for many years on a number of justice equity-focused efforts. They are popular speakers at our webinars and conferences, and for good reason. They're really good at what they do. Shalini Konanur is SALCO's executive director, and Atulya Sharman is supervising lawyer. And you'll find their bios in the chat. And now I'll pass it over to Shalini to get started.
Good morning, everyone. Thank you so much for joining us for this webinar. It's a packed hour and a half, so I'm going to dive right in. I wanted to let you know two things really quickly. One, I saw in the Q&A your comments about the chat being disabled, so those have been passed on to the organizers, and they're working on that piece. And secondly, we got in advance of the session a number of questions that what we're going to try to do with those questions is sort of interweave them into our presentation and give those answers. And for anybody else who has real-time questions, if you can just post them in the Q&A, I'll be managing that and looking at things, and we'll jump into those as well and try and get you as much information as we can. So we'll move on to the next slide. And as mentioned, we are here from the South Asian Legal Clinic. I'm not going to take a lot of time on this slide, but just to let you know, we're one of several, I think around 73 or 74 legal clinics in the province. And I'm sorry, I'm getting some noise. Whoever's talking, if they could mute, that would be amazing. Our clinic does a very high volume of immigration work, and why Atulya and I are speaking to you today is that we both also have really high caseloads in immigration. And I'll just let the organizers know that there are some people with raised hands, so I'm hoping that's not an issue with interpretation. And Mel, we see you, but we'll hopefully get the organizers to reach out to you. Next slide. And next slide. Can we jump to the next slide, Atulya? Perfect. So I want to give you a little bit of background around how immigration law comes together, because it's not just one thing. There are a number of things that come together in the law that give us what we call quote unquote immigration law. The first and foremost you will already know is the Immigration and Refugee Protection Act. I'm going to call it, and Atulya is going to call it IRPA from here on in. That's the short form. And that's really the nuts and bolts. That's the act that tells us about what immigration law is, what are the regulations, all of the things that we sort of base all our work on. In addition to that, we have something called the Citizenship Act and its regulations. You can already tell by the name that that is the act that governs how to get citizenship. Layered on top of those two pieces of law is our Canadian Charter of Rights and Freedoms, which guarantees certain fundamental rights and freedoms. Why is that important in this talk? It's because when we think about things like a race equity lens or an equity lens or a gender-based lens, we are also thinking about the way the Charter can be used to challenge decisions in immigration and to expand immigration to make sure that it's equitable for as many people as possible. And then finally, we have international instruments. Particularly, we have the Convention on Refugees, the Refugee Convention, that really outlines Canada's commitment and international obligation to taking refugees in and what we are meant to do. We have the Convention on the Rights of Child that protects children's rights in immigration decisions. And we haven't listed all of them, but there are other conventions that sort of intersect with immigration law. Can I get to the next slide? Okay. I think too, when we're talking about immigration law, it's really important to understand there's so many terms. There are so many terms and they matter because how you're classified by immigration matters to what you can and can't do, right? So we're going to talk to you today about temporary residence. So I'm not going to get into a very long definition of that term because it's coming. We're going to talk to you about permanent residents. Most of you will know what permanent residents are, but those are people in our old terms who we say landed immigrants. They are like in the States green card holders. We call them here permanent residents or PRs. Citizens, I think most of us will understand that term. One that you'll find a lot in the immigration legislation is foreign nationals. Foreign nationals are all of the other people who are here, right? Anyone who's not a PR, not a citizen, and that includes people with no status. So let's take it back to temporary residents. They will be called foreign nationals in the law. We also have here stateless people. So people who actually are here and really do not have sort of any connection to another state and have no other nationality. And we know in the refugee system, we have protected persons. So those are people who have received refugee protection from Canada under one of its many processes. And we have inadmissible people. People who our immigration system has found cannot remain here or cannot enter Canada for a variety of reasons. Next slide. Okay, so let us jump a little bit into temporary resident status because there's so many types of it in our system. The first one that most people are going to be familiar with is a visitor visa. Right? So these are those short-term visas that you can get to come and visit Canada. Sometimes it's for family, for tourism, for business. Generally, those visas are valid for up to 6 months and will allow you to travel across the country. It will not allow you to work in most cases or study. One of the things that's common at our clinic is that people get a little bit confused between an actual visitor visa and an entry visa. So we get lots of clients from calls from clients saying, well, I have this thing in my passport that says it's valid for 5 years for me to enter Canada. And they think that's a visa to be in Canada for 5 years. So just the distinction there that you will get permits to be able to enter. And when you enter, you will have a visitor visa. If it says nothing, it's a visa for 6 months that you have to extend, or you will see a stamp in your passport or a document given to you that tells you your visitor visa is for this long. So that's a really important distinction. We also have study permits for international students, and we'll be going into a little bit of detail there, but obviously those are people who are coming here to study. We have work permits. So we have foreign workers, foreign nationals who are working here, and those work permits can be very specific to an employer with a specific time limit, or in some cases, we grant people open work permits while they're making refugee claims if they've been approved in principle on an application like a humanitarian and compassionate application. And then we have the kicker, the most confusing one, temporary resident permits, right? So we have temporary resident visas, like visitor visas, study permits, work permits. And then we have a whole other category called temporary resident permits. Those are issued to people who are otherwise inadmissible, but have to be here for some reason. And so in our cases, lots of those temporary resident permits are issued to people who are here and they're going through a family law matter. So they really don't have any status, but they need to be here. And then we would apply for them under this TRP program to get them a temporary resident permit. So you have to understand that those are the four kind of basic building blocks of temporary status in Canada. Next slide, Atulya. Thank you. Most common question that we get is, how do people become a permanent resident? And that was one of the questions I think that was asked here. So we have different buckets in our immigration legislation for how to become a PR. One is, of course, the economic class. So these are workers, people who are already here, people who are not here, who are skilled workers, who are applying through our different streams, the Canadian Experience Class, Express Entry, Startup Visa, provincial nomination programs. All of these are called the economic class. So those are the people who are trying to get PR under that class. We also have the family class, right? And so that is the mechanism for people who are here to be able to sponsor and reunite with certain family members, right? There's lots of eligibility criteria for who is in the family class. And in some cases, like when you're sponsoring parents and grandparents, how much money you have to make to be able to sponsor them. And so that is a class for sort of reuniting and bringing your family here. It's most commonly used for partners and spouses, for children. And then unfortunately, we want it to be more commonly used for parent and grandparent sponsorship. We're going to talk to you about what the state of that program is now. Of course, we also, we're going to go back again, sorry. Yeah, we have the refugee protection class, and those are the people who are seeking refugee protection from the different programs of refugee work. We have the humanitarian and compassionate application. This is the catch-all to answer another question around, will we see a jump in humanitarian and compassionate applications going forward? We may very well. This is the catch-all application for people who are here and who really have no other option to try and get permanent residence. This is the application that they would use. And of course, the words are telling you what immigration is meant to be looking at. What are the humanitarian and compassionate reasons why they should be allowed to stay? The last one relates to the temporary resident permit holders. So if you have that TRP, remember that fourth box in the last slide, and if you've held it for a long period of time, that actually may give you a pathway to applying for permanent residence. Next slide. Okay. And
All right.
think I'm turning it over. Yeah.
Yes. Thank you, Shalini. So I'll be talking about some of the updates in the Canadian immigration over the last year and as recent as a few days ago of this month. So one of the most contentious things that we heard, sorry, why is it? Oh. All right, so the updates on the study permit program. So this is from 2024, but they did have a huge impact on the people who were already here and the new intake process. So that's why it's important to talk about that. One of the key things that the Immigration Canada did last year is to reduce the number of study permits that will be issued over the next 3 years. So it has decreased by about 35% for 2024 already. And you guys are already aware, the government came up with a plan that each province will have a certain set of quota of study permits that will be issued to each province. And they divided up with creating something called a provincial attested letter. We will talk about that in the next slides. And the focus of Immigration Refugee Canada has now shifted primarily on master's degree, doctoral degree, and postgraduate programs. At this point, the study permit renewals and current study permit holders are not impacted who are already inside the country. But there will be new changes. They will keep rolling out for the remainder of the 2025 and 2026, and we'll quickly talk about some of them. The intake cap for 2025 and 2026 for the number of study permits, it's at 437,000. And some of you might already know that the numbers are actually going way below that for a simple reason. The messaging that has gone out to the majorly study permit producing countries is that Canada is no longer creating a pathway to permanent residency. So numbers have gone down quite drastically, up in some provinces, in some cases, up to 40% and 50%. So then you have the provincial attestation letter, which was introduced in 2024. Part of the reason that the government did that is to control and manage how many students are triaging to which provinces, which cities, just to ensure that they can better manage the number of intakes for the international students. This has also created, there was a time where there was a lot of confusion when the program was introduced last year, that the PALs were issued abruptly in the middle of the session while the intake process was already started. And a lot of students were put in limbo. But now the program has fully rolled out completely, and it is creating a bit more of a efficiency within the system where the PALs are issued prior to the issuance of a study permit. So PAL becomes part of the study permit application package. That was not the case before. So that is an important change that took place at this in the last year's updates. Then you have the temporary study permit extensions, temporary policy extension that happened. As you guys might remember, there was a students could actually work unlimited number of hours full-time even while they were in school, and that policy expired in April of 2024. And then very recently, that policy has now been switched back to 24 hours per week that international students are allowed to work while their studies are full-time in session. They can continue to work full-time for the breaks that they have in their education. So if they have summer breaks or if they have reading breaks, they're still allowed to work full-time. The cost of livings that they have changed. Sorry, I think I missed the slide. Apologize. Yes. So one of the other things that changed, I apologize, I'm just having a bit of a technical challenge. So one of the big changes that happens with the GIC, some of you might know who deal with a lot of international students, that the guaranteed income supplement that they had to, certificate that they had to issue, show $10,000 bought through a Canadian financial institution. That was increased by double brought to $20,635 for one GIC, to show that this is how much money that they have to support themselves, the international students, while they're in the country. So this was something that has been not changed since 2004. That has remained at 10,000 since for about 2 decades. So that's why government actually decided to make those changes at that point last year. Then you had the postgraduate work permit, which is something of a pathway to permanent residency. As some of you would know, when somebody studies in Canada on a study permit for 1 year, they are eligible for PGWP for 1 year. If they study here in Canada for 2 years on a study permit, they are eligible for PGWP for 3 years. And that was really the selling point for a lot of international students to become permanent residents. Once they would have education here, they would then work for a few years and then be eligible for permanent residency through skilled immigration categories, more specifically, the Canadian Experience class. So as of September of 2024, they've made the licensing arrangement related course ineligible for a PGWP. And these courses were being delivered by some of the private colleges, and the government basically felt that there was a lack of oversight and they needed to make that changes. In addition to that, the master's and PhD degree graduates will remain eligible for a PGWP for 3 years without any reduction for time period for however number of time period that they have. As obviously, if you do a master's, it is at least 1 year or 2 years long. They will get 3 years. So PGWP, PhD is already a pretty long program. So they will be eligible for a 3-year PGWP as well. As of November 1st, 2024, the PGWP applicants are required to show a CLB 7. This is a Canadian language benchmark of 7 for university graduate and CLB 5 for college graduates to apply for PGWP. Now, this is a bit of a challenging situation for a lot of international students for a simple reason. The international students, when they're making an application to come to Canada, they have already appeared for an IELTS or SALCO or some sort of an English language testing test. Now they will be required to reappear if their test scores have expired. They will have to do that over and again, kind of adding up an additional burden on them while they're trying to figure out what sort of jobs they're going to be getting. So it is creating a bit of a challenge, but this is now the rule that the government is following. As of November 1st, 2024, a field of study requirement have been added for colleges and university program graduates for PGWP. Now, what that means is, and this is something that they have done in the past, in early 2000s, they used to have this field of study requirements for PGWPs, which means if somebody studied a particular course in university or colleges, say it was science related or mathematics related, their job, they will only get a PGWP for the jobs that they can get in that field of study. It's not going to be randomly available for everything. Length of PGWP, as I already said, remains for 3 years for master's and PhD graduates. Now, spousal open work permits. Now, when Immigration, Refugees, Citizenship Canada opened up spousal open work permits for spouses of work permit holders, study permit holders, or PGWP holders, otherwise, their family members could actually come to Canada and be with them and while their spouse is studying or working. Now, this makes Canada an ultra competitive destination across the globe because people want who are the skill set that we want in this country. If their spouses can come here and work while they're studying or working themselves, Canada becomes a competitive market for rest of the other countries who are also trying to draw attention to those people in the field of information technology, in AI, in science and technology, those sort of individuals. So that is now being limited by IRCC as of 2025. So effective January 21st, 2025, only spouses of certain international students and foreign workers will be able to apply for the family open work permits. Now, they will only be available to people who are here on a master's program that are 16 months or longer, doctoral programs, or select professional eligible programs. Now, there's a list that just got updated on IRCC website, and a lot of these courses are related to STEM, science, technology, engineering, and mathematics. Family open work permit will also be limited to spouses of foreign workers who are employed at EER 0 or 1 occupation, or select tier 3, 2 or 3 occupations in sectors with labor shortages or linked to government priorities. Now, what that means is if somebody has an employment and they are working at a higher position as a manager or as
Atulya, this is the
sorry, am I going
interpretation
too
team.
fast?
No,
Yeah,
we
I
had a
apologize.
glitch in our technical. Could you just go back to the second point, please?
Okay, sorry. Yes.
I'm so
So
sorry. Thank you.
no, that's okay. I'm not going too fast, right?
No, it's not too fast. We had a technical problem with the cameras.
Okay.
Thank you.
So family open work permits will be limited to spouses of international students who are enrolled in master's program that are at least 16 months or longer, doctoral program, so PhD, and select professional and eligible program with a list of those programs available on IRCC website. Now, this is an important change that has happened. Up until now, students who were coming for any publicly funded college program, post program, they could bring their spouse. That will no longer be the case. So the SOWPs are now limited to these 3 specific categories. Third point, the family open work permits will also be limited to spouses of foreign workers who are employed in tier 0, 1, and select tier 2 and 3 occupations. Now this tier, I'm saying this tier, it's TEER, training, education, employment, process that the government follows, which erstwhile used to be called NOC, the National Occupation Classification. So this is the tier part of that. And as per the IRCC, they'll be reducing over 100,000 SOWPs over the next 3 years. Now, that is a major breakaway change from what the government has been pursuing post-COVID. So this is a bit of a course correction on IRCC's part that they've been talking about. Hang on a second. Now, this is a bit of a challenging part that the government has essentially, it appears that they have completely eliminated trying to reduce the SOWPs as much as they can. In addition, the foreign workers must also have at least 16 months remaining on their work permits at the time when their spouse applies for the open work permit application. Now, this is essentially closing the door for a lot of people. We know for a fact, as practicing immigration lawyers, a lot of people do not have that much time remaining on their permits while they can make that application for their spouses. Up until now, the regulation was that you should have at least
Just
6
a
months.
request, Atulya, to slow down a bit.
Okay. All right. So up until now, it was up 6 months validity that was required on the permits of the spouses for them to make an application for an open work permit for this dependent spouse. Dependent children of foreign workers will no longer be eligible for permits.
Atulya, can we take a pause and just, I'm going to run through some of the chat questions.
Yeah.
Just stay unmuted and we can kind of answer them together. Okay, so the first question is, will you be touching on the difference between immigration status and refugee options? I'm going to direct you just to let everybody know you are going to be getting a copy of this presentation. I'll direct you back to the slide where I talked about all of the different ways that you can get permanent residence. So we have a refugee program, economic, family class, humanitarian and compassionate class, temporary resident permit pathway, and all of the temporary stuff. So those are the major differences. And the law is going to differentiate on how you would become a temporary resident or a permanent resident, depending on the program. The next question was just a clarification on that entry visa point. And I'm glad somebody asked it. So what happens is if I want to come to Canada, say from India, that's where my family's from, I will apply for a visa to come. I will get something called a single entry or a multiple entry visa. What that is telling me is that I am allowed to enter Canada. And if you get a multiple entry visa, they're usually valid for 5 years. It's not telling me that once I enter, I can stay for 5 years. It's telling me that for the next 5 years, I can enter as many times as I want. When I enter, when my foot hits the ground in Canada, then what the law says is I'm allowed to be here for 6 months, unless they've stamped something different into my passport saying, oh, you're only allowed to be here for 1 month. Or if I have a document that says, we're giving you this visa for 1 year, right? Most people are not going to have that. They're going to set foot with their multiple entry visa. And so they have 6 months. So what they need to know is that once they set foot, if they want to stay longer, all they have to do is apply from within Canada to extend their stay. If they don't do that, then they will fall out of status here. Okay? So I hope that answers that question. Great point here. Some think if you are a PR, you do not have refugee status. You left your country as a refugee, but PR is an immigration category. It's a great point because it raises something that's happening now in immigration law that's not in this presentation. If you become a permanent resident, that is your immigration status. But if you become a permanent resident because you came as a refugee and are found to be a protected person, why does that matter? Once you have permanent residence, you're PR, right? Why it matters is because we now have pieces of legislation in immigration called cessation, meaning if I am a refugee claimant, again, say from India, I get my permanent residence, and then I decide I'm going to go back to India for a visit. Immigration authorities can come after me and say, wait a second, you told us that you had fear of returning to your home country, and now you're returning to your home country. So we may take back your PR status because you're not actually having those refugee conditions anymore. So we have to be very careful with our clients around telling them that they can't, what the term is called, re-avail. What that means is if you've come from a country where you've told Canada you're scared to be in that country, scared for your life, scared for the conditions, and you want to go back, you risk potentially losing your permanent resident status. So you have to be very careful there. Those are all situations that we do not expect all of you to give legal advice on. What we want you to do is think about, oh, this might be an issue. Let this person talk to somebody. The next question, for those applying for a TRV because of the Gaza crisis, when they arrive, can they apply for PR? Right now, as it stands, the answer is no. Those temporary resident visas, that's what a TRV is. My understanding is that they are valid for 3 years. If you want to apply for permanent residence, go back to my slide on the different pathways to PR. You got to fit into one of those unless the government creates a policy that allows you. As it stands, there is not one. And you can see that in the Ukrainian example, which we're going to answer a question on in just a minute. Next question. Could you mention the difference between refugee claimant and asylum seeker? No difference. They're the same term. Some people will say asylum seeker, some people will say refugee claimant. It's just the same thing. And Atulya, jump in if you want to add anything at any point. Did the recent Ukrainians' arrival to Canada come through TRPs? No. So the QAT, the CUEAT, I might be getting the acronym wrong. The QAT is just like the TRVs for the Gaza crisis. A lot of the people who came, I think over 100,000 people, came on those same TRVs, which are for many of them expiring on March 31st, 2025. And so what the government has said is that those people can renew now and extend those TRVs. They're not TRPs. And what I do want to say there is the challenge for a lot of the Ukrainian clients is that in order to renew, you have to have a valid passport. And are you going to be able to get a valid passport out of the Ukrainian embassy right now? No, right? And so what you need to do is immigration officers always have the discretion to waive requirements when they're impossible to meet. So you have to explain what you tried to do and how it's impossible to meet and apply for those extensions. Really critical for those people on the QETs.
And if, sorry,
Go ahead,
just
go ahead.
to add
Yeah.
to that, and if for whatever reason it's not possible to get a renewed passport, we've had cases where people have applied for a TRP successfully and have gotten that. Yeah.
Yeah, so that is an option to try and get the TRP, but they are alert and alive at IRCC to the issue that the Ukrainian
Yeah.
community is having. And so there will be a lot of likely discretion used to get people over that hurdle. Another question we have, there was a change on Friday about including elementary and high school students in the overall student cap. So I actually was looking at that. Atulya, you want to jump in?
Okay, so that one stays. Okay, so I was actually curious. So when the overall cap is announced, those categories are always there. You have to understand people who might be coming here on work permits, who are on ICT categories, intra-company transfer categories, or other categories, and who would have their own dependent kids. Those dependent children who need a study permit, they will most likely are going to be captured for those categories. Now, there's a lot of understanding that people feel that students can come from abroad to elementary school directly just on that category of visa. That is a bit of it doesn't really work that way. It used to be like many years ago, but now no longer that. But yes, the answer is there is a specific cap for those students, but those are mostly under dependent categories, not a standalone category.
And I think when you hear in the news caps on international students, they're actually referencing caps on the post-secondary most of the time, right?
Correct.
Yeah. Another question, and you can take it or I can take it. For students who work full-time during the break, is it a 24-hour limit? So I know actually from the policy that if you're on a DLI, like a designated learning institute authorized break, there should be no cap on your working hours during the break.
Correct.
There's only a cap while you're studying. Okay, Atulya, can you repeat the number of hours of work permitted during a week during the school term? I think it's 20, right?
Sorry, the voice is not coming. The hours?
Yeah, the number
It's
of
24 hours.
24.
Yeah, the rule is
sorry.
now 24 hours. Yes.
Yeah. Okay. Perfect. Next question is on international students. Are international students permitted to take on full-time co-op during their studies, or are they only allowed to do co-op under 24 hours?
Sorry, can you repeat that for the interpreter, please?
Yes. Are international students permitted to take on full-time co-op during their studies, or are they only allowed to do co-op of under 24 hours of work also?
Okay, so that would depend on the nature of the co-op that has been approved for that course. And the co-op work permit is actually mentions that when you get a work permit at the port of entry with your study permit. Yeah.
So you have to look at your documents
Yeah.
to know what applies to you. Next question. For international students, do they have to pay for 1 year tuition or 1 semester?
Okay, I think we're getting into different territory here. It's whatever the requirement is in effect. That's a very technical question because it goes through two different processes. One is the institution. So educational institution will say you pay a certain 1 semester fee or 2 semester fee, and the study permit application generally for SDS category, which was in effect up until a few months ago when they scrapped it, it was the 1-year tuition fee. So it's anybody's guess now. I think the minimum that is required needs to be paid. I don't want to be, I don't want to give specific information on that.
Okay. And so the other thing that's happening in the Q&A is there's like very, very specific questions, especially on international students, hours worked, pathways to work permit. What I think might be better here is, because this is meant to be more of a general overview than like very sort of dive in, is that hopefully we can take a look at those chat questions, because we just won't have time to be able to answer super specific questions. And then we will work with OCASI to figure out maybe if we need to have a follow-up session, or if we can do this by sending you a written sort of answer to some of those things. Because I see people asking about tier 2 jobs, work hours for pathway. Those are things that are really specific. And unfortunately, lots of times in our questions, it's what Atulya said. It's really going to also depend on the individual's profile and what we need to look at. So sometimes it's not easy to give you a general answer, but we'll try our best to navigate some of those questions, because there are lots of those. Okay. One that I think is a good one, maybe that you could answer right now, is, do you know if there are changes in regards to the post PSWP and spouse work permit when a passport expires before the term of 3 years of the PSWP ends?
PGWP, right?
PG.
Yeah. So there's a specific process within immigration. If someone has a expiring passport, and they should be getting a PGWP that is valid for 3 years, but because of the short validity of the passport, well, technically, first try to get a new passport. That's the first thing that everybody should try to do that. If for whatever reason that happens, there is a specific process by our IRCC to get the new work permit pasted on the new passport once you get the validity extended. So if you go on IRCC website, it specifically mentions that. And this is also fairly new, like a few years ago it started, because that was a big challenge for a lot of international students. They would get shortchanged on their PGWP validity just because of the validity of their passport.
Perfect. So I am going to pause. There's a lot of questions in the chat, but I think we will lose time if we don't carry on and do a little bit more of the presentation. What we might do is truncate our comments a little on the presentation so that we can get to some of those questions. And whatever we cannot get to, we will try to figure out with OCASI what a best next step is. Because today was meant to be sort of giving you updates, but I can see that a lot of the questions in the chat are more about the details of specific programs. So we may have to consider what we can do to support you on those answers too. So we'll jump back into the presentation now, and then let's see how we do on the Q&A and what we can get to following that. Okay, so Atulya, I think you're taking the next couple of slides.
Yeah. Okay. So we're just going to quickly talk about the other immigration updates related to citizenship, caregiver, PGP, the parent-grandparent category, and so on. So moving along. So my presentation is visible, right? So proposed amendments to the Citizenship Act, and this was a big thing that came out of the case law in 2023, where the government allowed for the Canadian citizens who were like lost Canadians, and they wanted to make those changes to make those people also Canadian citizens who were born abroad, even after the second generation, because if you remember, Stephen Harper government basically changed the first generation cutoff rule several years ago. So in the summer of last year, in May 2024, the current immigration minister basically brought in a bill C-71 to make the amendments to the Citizenship Act. Unfortunately, that bill has lapsed because the parliament is now prorogued up until March 2025. even though, so there is a possibility that the government may try to go back to the court and request an extension, but that looks unlikely because of the impending election that might happen right after the new Liberal Party leader and Prime Minister has decided. So that's where the situation is at this point. The other latest update, and I think somebody asked about this in the questions, the live-in caregiver category. As you guys know, all the pilot programs for the live-in caregiver home care support program pilots were closed. But the new program, and this just happened 4 days ago, the new program will launch on March 31st, 2025. And this will essentially create a clear PR pathway for live-in caregivers, home support workers, and they will be eligible to work right from the time they get in. And by the time, as soon as they land, they will be eligible for permanent residency without waiting on for accumulating those number of hours and the years of work experience, which was creating a huge impediment for a lot of the qualified individuals. The eligibility criteria, I won't go into that. It's on the slide, and you guys will get a copy of the slide after our presentation. All right, I think. Oh no, sorry, that's me.
I can take over. I'm okay to take over. I'll take over.
Okay, sure,
Yeah?
sure.
Okay, sounds good. Okay, so remember I talked to you about being able to sponsor your parents and grandparents. What we know now is actually the thing in bold. IRCC has paused that program. They are not allowing any new applications to come in on the parent-grandparent sponsorship. So if I wanted to try and sponsor my mom now, I just cannot. What they are doing now is dealing with the backlog. So I believe that it was from people who applied in 2020 and before. They are now bringing up those applications again on a lottery basis, and they've capped how many they'll look at, right? At 15,000 in a year. So what does that mean for people? It means if you're in the system, you will eventually be processed. The processing times are likely to go up. You know, when about 15 years ago, the processing time was 7 to 8 years. I had clients whose parents passed while they were waiting for processing. It's a very difficult space, the parent-grandparent sponsorship. What is still around is the super visa. For those people who meet the minimum necessary income, they can continue to apply for super visas for their parents to come here long term. The only issue with that is they're not eligible for healthcare, they're not eligible for benefits here, so it becomes a hard life. Next slide. Of course, we still have the financial assistance for Gazans who arrived here as of Jan 16, 2025. I'm not going to read the details of the slide. You are going to get the presentation. And of course, we talked about in the answers, the piece around the temporary resident visas also for Gazans, as well as a new update. Next slide. Really quickly, we had an announcement last week, I think, or the week before, on the end of what's known as flag polling. So for those of you who don't know, that's the term that people use for when, say I'm a foreign national, I'm here, I want to extend my visitor visa. I don't want to put it in online. I can go to Buffalo and go into the US as long as I have a visa there and then come back. And Canada would then look and say, okay, we're going to allow you to re-enter. New 6 months, your foot is back in Canada. That's your visa extension. That is no longer allowed. So for foreign nationals who are trying to extend work permits, who are trying to extend study permits, who are trying to extend visas, you cannot cross and come back and think that you're going to be processed and let in. They are saying that they are not going to process those things. The only way to do those extensions now is online applications. And so make sure your clients know that, because they're going to get stuck in a gray space. This is all the result of our tightening of our borders and what's going on in our conversations with our partners to the south. Next slide. We know this, and there were questions about it. They're dropping numbers left, right, and center, and that is going to have an impact on settlement services and other services. We've already started to see that, and we really have to start thinking about what does that mean in terms of, the services that incredible agencies like the ones that most of you are here representing do. We're also probably going to see a slowdown in processing times. So those backlogs that we haven't caught up from are likely going to get even larger. Next slide. This seems like the doom and gloom section of the presentation. Can you jump to the next slide? Yeah. Okay. So we wanted to talk really quickly about dealing with status. So Atulya's talked about that a lot. You can see these many programs where status can be tied to your spouse, right? That they're either sponsoring you, or you're the spouse of a refugee claimant, or you're the spouse of a permanent or a temporary work permit holder, or they're adding you to their application for permanent residence. So there's lots of people here who are not what we call the principal applicant in some sort of application. They're actually the spouse or partner of the applicant. And so their status can be tied to their spouse. Why we raise it is because if that relationship breaks down, what happens to me? If my husband was applying for permanent residence under the economic class and we break down, I'm suddenly now not included. I'm out of status, right? We also need to understand that your status impacts your connection to entitlements. Your status will tell you whether you're eligible for OHIP, for federal interim health, for social assistance, for subsidized housing, and for Canada Child Benefit. There is a great chart, I think, on something called Steps to Justice, which actually breaks down for you. If you are this, you can get this. If your status is this, you can get this. And if you're not sure, I recommend that you look at that, or you can get in touch with us at the South Asian Legal Clinic too, to figure that out for your clients. Okay. So many things can lead to loss of status in Canada, right? If your relationship breaks down and you're a spouse, that's one that I just talked about, right? If I sponsor my partner, but I don't list my children, then it's potential that they won't be able to come here. I may be found to have misrepresented myself. I may lose my own status. There are a lot of tricky things. Why do I raise it? I raise it because anyone who's going to work with a client to fill out forms has to make sure that client understands that they need to be over-inclusive and truthful in what they're putting in. People oftentimes will list things thinking, I'm going to do it this way so I can get permanent residence. They don't think about what happens after. If you get caught, if you haven't listed a child, there are a whole bunch of ways in which, okay, maybe you got permanent residence by not telling something. Good chance you might lose it. So you got to be very, very, very careful there, right? Lots of people come to us because they have failed to extend their temporary resident status. They didn't realize that it's expired, right? People need to understand that they need to extend, and in a limited window of 90 days within losing status, they could potentially restore that status. So these are all kind of things that you need to think about over here when we're thinking about immigration. Again, we're not suggesting that you're going to get all of this right. What we want you to remember is things are not always as simple as when clients come to you, and sometimes it's a good thing to plug them in, right? This is a really key warning when you're working with people with what we call precarious immigration status. Precarious can mean even permanent residence. If they've misrepresented, it can mean having no status, and it can mean being here temporarily. Lots of people will come and will not have a full understanding of their history. Before jumping into applying for anything in immigration, we spend lots of time investigating what this client may have already told immigration. We want to make sure that we are not putting something in that contradicts something they've said to immigration in the past. That's critical because what it can lead to is inadmissibility. And there was a question around what is inadmissibility for temporary resident permits. Inadmissibility generally in these scenarios are for people who've misrepresented, who've been convicted of a serious crime, who have a medical issue that means that they won't be landed because they cost too much for our healthcare system. These are all things coming out of immigration law. If any of those things happen, you will become inadmissible. And if you become inadmissible, you can be removed. And our only fix for you is to try and get you a temporary resident permit and to do a humanitarian and compassionate application. So you also want to be careful of calling immigration and giving word that you're working with a client who may or may not have status. We don't know if they have warrants. So in those cases, that's when you want to connect them to legal help. Okay, we'll jump to the next slide. Really quickly, so what do we do with all of our clients who come to us and who've left a situation of violence? And this happens at our clinic, I think at least 3 times a day. It's heartbreaking. Those are clients who are either here as visitors, students, workers, and sometimes with no status at all. And in those cases, immigration has created something called the Family Violence Temporary Resident Permit. So there's a specific program where particularly legal practitioners can advocate to get a temporary resident because of the family violence situation. Next slide. This gives you a lot of detail on the very specific nitty-gritties of what that family violence TRP looks like and what an immigration officer is looking at in terms of granting it. And I don't want to read the slides out to you, and I know now that you'll be getting them. So I'll ask you to sort of bookmark this and just read that. And the examples are the ones that we've kind of talked about, right? I am being sponsored and I'm here in the country, and then suddenly we break down. Most of the time, my sponsor will pull that sponsorship application. We're not together anymore. What do I do? Right? I've been misled, right? I'm an international student and I've met someone here and I've been misled into letting my international study permit lapse, and because I'm going to be here with my partner. And then there's violence and you leave the partner. Now you're out of status. You didn't extend your study permit and you don't know what to do. So there are many, many examples of that happening. Can I jump to the next slide? Okay. Question here around the policy itself says you can apply for this if you have no status. So sometimes people come to us and they are visitors or they are workers. So they have some sort of status and they're trying to find out, should they apply for the temporary resident permit on family violence? It's a tricky thing. We've done it both ways. The policy says you have to be out of status to apply, but in fact, we found actually that they've granted it to people even with temporary resident status. And so if you're not sure if a client qualifies, just contact a legal clinic and have them do the assessment. Next slide. And this is how you apply. Again, I'm not going to read out the nitty-gritty. I would say though that these applications do require more advocacy than I originally thought that they would. And so this is an area where if you can link someone to legal assistance, I think it would benefit them. I don't always say that in immigration. There's many things in immigration that I think people can do on their own. This is one of those programs where I think it would be beneficial actually to have someone support the client to do it. I talked to you about humanitarian and compassionate applications. It's our catch-all. It's the only way to get permanent residence for a lot of non-status clients in the country who don't really fit any other program. And most of those people, when they're out of status, don't fit any of those other programs. And so this is a critical one in the work that we do at legal clinics for trying to figure out how to help probably some of the most marginalized, vulnerable people within that system. There's a fast track within this program also for cases of intimate partner domestic violence. You can jump to the next slide. You can go to the next one, Atulya. Yeah. So this is the slide that talks to you about that fast track around cases of family violence and what immigration officers are listening for. It's pretty clear, the slide, around the evidence that they're looking for and the experience of violence. Again, these are applications that require significant advocacy. I would strongly recommend, if the client is low income, contacting legal aid for a certificate or contacting a legal clinic to get support. And if they are able to pay someone to help them with these applications, I would recommend it. Next slide. Can jump again, Atulya. Okay. I think one thing that's really critical that we see a lot of, and sorry, I'm getting volume from somebody's mic. One thing that is critical that we see a lot of is people who, for some reason, come to us because they haven't extended their temporary status. And so it's really critical that we tell people that they should apply for an extension. Our rule of thumb is at least 2 months before the status is going to expire, but even the day before, if they didn't realize. If they miss that deadline, there is a 90-day period after where you can apply to restore your status. If you're outside all of those deadlines, then we have to scratch our heads and think about what the pathway is. Sometimes we used to tell people to flagpole and see if they could get back in the country. That is gone. That door is shut. And so those are people who will definitely need some advice on, what do we do? Do we do a temporary resident permit? Do we try for a visitor visa? A lot of these decisions are discretionary from immigration. So unfortunately, it's a tricky thing around strategy to figure out what will work and what won't. Next slide. So open work permit holders. So Atulya gave you a whole bunch of information on our traditional work permit system, but we also have open work permits depending on the program that you're in. So Ukrainian nationals who came are eligible for open work permits. Recent graduates from Hong Kong, spouses and common law partners who are being sponsored, vulnerable workers, people who've been approved in principle on a humanitarian and compassionate application, dependents of people who are applying for permanent residence, refugee claimants, and this list is long. What's tricky about it is the people eligible for an open work permit are dependent on the stream that they're in, and there's no one place that you can find this list of every open work permit. You just have to understand the programs and look, but there are a number of people. And as the name suggests, open work permit means it's not tied to a particular employer, so you can work anywhere, which is a really great thing. Next slide. Again, these are the people who can apply for an open work permit, right? We know that refugee claimants can. We know that if you have a removal order, but it's not enforceable. For example, at one point, there were people with removal orders to Haiti, but the government made a decision that we're not sending people back to Haiti right now, right? This was historical. And so they were eligible for open work permits. If you have a temporary resident permit, remember that fourth bucket I talked about, you can get an open work permit. So there are a whole kind of bunch of different streams for who can apply. One really good change that happened in 2019 was, one of the things we see often is workers who are in a closed work permit. So I have a person who works for me and they can only work for me. And I know that. So what I decide to do is I decide to make them work 20 hours a day. I decide that I'm going to scream and yell at them. I decide that I'm going to flirt with them all day, right? They're being abused in my workplace. And so we had, for a long time, many people had advocated that those people will not leave, because if they do, they violate their closed work permit, which means they're out of status and they have to leave. Gives me a lot of power as an employer, right? To be abusive and to be exploitative. So they've created this program for vulnerable workers where they can leave and they can apply to immigration for an open work permit, and they can give the information about what was happening in their workplace. And if they're a vulnerable worker, they will be able to get that open work permit. And we've had some good success with that and some fast success recently, actually. And you can see Atulya nodding because I think one of his cases was one of the fastest ones we'd ever seen granted. Next slide. Okay, so there we go. We've come to the end of our formal presentation. It's a lot of information. I hope that you will look at it in detail and digest some of the things I skipped over. I want to take us now to the chat. And there are 80 open questions. There is no way we're going to get to all of them, but we're going to try and do our best to get to as many as we can. I think I'm going to jump to some of the ones that may not have sort of been a little bit covered in the presentation. First question is, how many times can a visitor visa be renewed? Rule of thumb is you might get 2 or 3 max. There's no limit, but generally what I've seen in my work is that after the 3rd one, they're not going to renew again. Atulya, do you have a different experience than that, or?
No, I think there's no specific time limit. They will always assess the legitimacy of the extension, the purpose of that visit for that extension. They will keep looking at that, and it's like on a case-by-case basis. Yeah.
Perfect. Okay. This is an attestation letter question. So I think what we'll do is some of those ones that are very specific to work permits and study permits, we might put them together and think about a different session or a way to answer those questions in bulk together at a later time. Parents who already have a valid Canadian visa till 2027, 2028 can come and go normally and stay for 6 months once they've come. Correct, right? That's entry and then visa, however long you're allowed to stay. Here's a great question on cessation. How does cessation apply if the person is a citizen? So our legislation allows cessation if you're a citizen or a permanent resident. However, it's a bit harder to cessate citizenship than it is permanent residence, but it's possible. And so the next question is, can you reavail once you're a Canadian citizen? So on the cessation question, one of the things that is happening is that there are challenges now in the courts. And the challenges are, if I applied as a refugee from Sri Lanka, say, in the late 80s, early 90s, I was coming because they were in civil war, right? And so that makes sense. It is now 2025. The conditions of that country have changed, and I want to go back and see my family, right? There's a possibility that IRCC will come after me for cessation because I went back to Sri Lanka. My argument back will be my refugee claim was valid at the time that I made it. Those conditions were present. I was scared for my life. The conditions have changed. It's 25 years later, right? Whether that's going to work or not, I wish I could tell you 100% it will. There are challenges in the courts right now around this very issue of cessation. So what we tell people is, if you've got to reavail, you have to reavail. You know, we have people call us who are saying, my parent is dying, right? And for me, if I had to choose between losing my citizenship or PR and going to see my dying parent, you know, honestly, I probably would choose to go see my dying parent and then try to explain myself to IRCC. As a lawyer, what I have to tell people is you run the risk, right? When you reavail, you run the risk of potential loss of citizenship or PR. It's probably a small risk, but it's still there. The law doesn't give you a way to say, no, once you're a citizen, there's no cessation, or no, if there's a good reason, there's no cessation. It's just a risk you're taking. Okay. All right. Does anyone have information on the TRVs for newcomers from Gaza who came in through the Crisis in Gaza special measure? What services are they eligible for? And are there any agencies? I don't have enough information on that, but Ansuya Chetty is asking the larger group here of people, if people know the details of that, if you could actually just email Ansuya. And Atulya, I don't know if you have any more info. Okay. And here's a question from Obasa. Can a visitor register kids in school? This is a tricky question because our Education Act in Ontario says to us that children are allowed to be in school, but school boards are doing different things around whether they will allow children to register for school. What I do want to say on this question is I would actually ask you to contact Justice for Children and Youth, which is a sister legal clinic to ours, Justice for Children and Youth. They are looking actively at these cases around Ontario in particular, around what boards are doing to allow and not allow people to register their children for school. Most schools are going to tell you if you're on a straight visitor visa that you're not eligible for education here. It gets trickier when you're here for longer. Is there anything you want to add to that, Atulya?
No, I think that's you've covered that.
Okay.
I'm just typing some of the answers in the chats as well.
Perfect. On the really, really specific program related questions like PGWP, CLB, and CLC, we're going to have to figure out a way to answer those more specifically because that could take us down a long path of talking about sort of those programs. Atulya will try to jump into those. I'm going to jump to what's the difference between a temporary resident permit and a temporary resident visa. That's a great question. The temporary resident permit allows you actually to different entitlements. A temporary resident permit, once you have one, gives you an ability to apply for an open work permit, gives you the ability to apply for a study permit, and at a certain point will allow you actually to potentially have healthcare coverage. And if you hold it, depending on the type, for 3 to 5 years, it's your pathway to permanent residence. A temporary resident visa is just a visa to visit. You're not entitled to any of the benefits or related things to Canada. A temporary resident permit will allow you to apply for social assistance, all sorts of things. So it's a great illustration, actually, that question of what's the difference, right, between the two. So that is one of the pretty clear differences between the two. And I've just lost my place here. 1 second. Okay. Is a travel document valid to apply for a CUETE extension? It can be, right? So what's happening on those extension applications is you have to just present any kind of document that you have, and then you can go from there and see what they'll do. Yeah. And I'm just scrolling through here. This is a good one here. I got my work permit when I was inside Canada and now I'm outside Canada. Can I come back with just my work permit? It depends actually on whether your work permit allowed you to travel and re-enter, and it will say on the permit. If it didn't allow you to travel and re-enter and you left, then usually that invalidates the work permit. Atulya, would you agree with that?
Sorry, I missed that. So somebody was on a work permit and then went back. So that would depend on the counterfoil that is stamped on your passport.
Yes.
If that has expired, you will need a new visit visa to come into the country, even though you may have a paper-based work permit in your possession.
Perfect. Atulya, there's a question here on a point in your presentation. Can you elaborate on this point in your presentation? Dependent children of foreign workers will no longer be eligible.
Okay, we're still looking at what that would mean. So because this came out exactly how it is written. So it is verbatim taken from IRCC website in their notification that they issued a few days ago. So we're still looking at it. Does that mean it's only applicable to students' dependent children or foreign workers' dependent children, or what kind of permit is not available to those dependent children? Is it the study permit, work permit, or any kind of permit? So that is something we're still waiting for clarity from IRCC on this.
A great question around refugee claimants and fraud, right? So we're seeing a lot of people who are finding themselves now in Canada in a really vulnerable position. And lots of times, if you're really vulnerable, you become desperate and you become sort of open to people taking advantage of that desperation. So what's described in the question is paying $6,000 to an interpreter to make a connection to a lawyer. And can anything be done? These are really, really tough situations. Sorry, I'm getting something in some volume in the chat. If people could mute, yeah. I think one of the things is if it's sort of a professional interpretation service, then you can make a complaint directly there. The police have been pretty reticent to pick up these kinds of things. It's going to be difficult from a legal perspective to try to sue somebody. You'd have to figure out if there's a way to do it. So I think the reality is on the back end, on the legal side, there's not a lot of recourse. So what we need to do, and we've been talking about it at the clinic, and I hope all of you will be, is how we get the word out to people in education to deal with that immigration fraud. We are looking very actively at a social media campaign to let people know. But, you know, I'm in a room with hundreds of people right now. And if you can also think about yourselves and in your organizations, what can be done to get the word out? Because I suspect we're going to see more fraud as people become more desperate. And that tags to the question that comes after, which is, for people who no longer meet any of the immigration criteria because of recent updates, are they going to be asked to leave the country? They might be. And why I say might is our enforcement arm for immigration is an entirely different ministry. It's Canada Border Services Agency, right? And they're tasked with the enforcement piece. They don't have the capacity really to enforce everything that needs to be enforced. So they're going to prioritize. So, you know, first and foremost, they're generally prioritizing people who are criminally inadmissible. What we do see is they prioritize failed refugee claimants. Are they now going to prioritize people who've overstayed a visa? It's going to be difficult because our system doesn't necessarily know. If I come here as a visitor and I overstay, the system, I think, doesn't necessarily know that I'm still here. And so it's tricky. What makes it difficult for people, though, is that if they want to try and get some sort of status in the future, they will, when they're filling out their histories, make it evident, it'll become evident to Canada that they overstayed for a long time and didn't leave on their own, and that's going to impact future applications. So are they going to be coming after them straight away? Unlikely. But to be honest, I don't have a 100% answer because we don't know what the priority of any government is on enforcement until they announce that to us, right? And so that's kind of a tricky piece around that. I'm just going to scroll through these questions a little bit more and take a look at some of them. During the school break, again, it's unlimited number of hours that you can work. If it's a legitimate break, you're allowed to do that, right? There is a point, is it possible to have some of the questions answered as a follow-up without, yep, so we're trying to get to that too. Can visitors apply for a work permit? Generally, no. It's very difficult to get a work permit from within Canada unless you're part of one of those programs that allows those open work permits. Atulya, do you have a comment on that?
Yeah, so after COVID, they had allowed visitors who were inside the country to make a work permit application. But last year, towards the end of last year, they took away that privilege. And so visit visa holders can no longer apply for work permit unless, as Shalini pointed out, you fall under one of those categories that we mentioned in the presentation.
Okay, we're going to take a few more questions and then wrap you up because we only have 6 minutes remaining. So for refugee claimants who have a condition related to education, can it be waived to do some study? You can try, and it'll be up to sort of the discretion of the officer looking at that request, whether they'll give it. It really depends, again, on what is the condition. So remember what Atulya said about work permits and what's stamped on the actual permit in terms of conditions. Generally, I've not been very successful when I've looked at somebody's temporary permit and there's a condition on it of getting it waived. Again, it's not 100% answer, but it's generally been my experience. Atulya, do you want to grab this one? What are the criteria for international students to qualify for permanent residence?
I mean, that's $1 million question in the
I know.
current climate.
That's why I asked it.
I think probably the one who has asked the question would obviously know there are several pathways, but specifically for international students, it is studying in Canada, you get additional points, then working in Canada, you get additional points, and then making an application for Canadian Experience Class. And for that category, the points right now within the express entry stream is pretty high. But with people who have education from back home, who have work experience from back home at least for 1 year, and have studied in Canada for, say, 2 years, and have worked in Canada for at least 2 years, are probably getting that picked up through the CEC draws. So that's what it is. If someone doesn't have work experience from their home country and have only studied here, I think likelihood of them getting picked up for any CEC draw is pretty low. Yeah.
Perfect. I want to take one of the advanced questions that was asked, which is what are the changes that asylum claimants processes for those coming in from the US into Canada? And why I want to take that is because of what's happening right now. So I want to, what hasn't been in our presentation, because it's not an update technically, is that Canada and the US are signatories to a Safe Third Country agreement. And that agreement says that unless you meet one of the exceptions, if you try to cross into Canada from the US to seek refugee protection, you will be sent back to the US to do it there. So what it is saying, we see each other as safe third countries. So if you step foot in Canada first, you make your claim there. If you step foot in the US first, you make your claim there. We will not let you cross back and forth. And there are some exceptions if you have a family member here, if you're an unaccompanied minor, a person under 18, a document holder. So there are some exceptions where Canada will let you in. Why I want to answer this question is we all know what's going on around the conversation right now on tightening the border. So the Safe Third Country was always in place, but I do think that it is going to be enforced with a level of strictness that potentially wasn't there before. So we need to really be mindful of that Safe Third Country agreement and understanding what that means. Do you want to add anything there, Atulya?
No, I'm okay. I think you covered pretty much everything.
Okay, so there's lots of questions in the chat that we're not going to get to because we need to end. I see Jassi popping up.
I tried everything.
I want to leave you with 2 things, right? Number one, immigration is one of the most difficult areas that we practice because it changes constantly. You can see announcement after announcement, policy after policy, minute changes that you have to read and read and read and dissect to fully understand. And so what you need to understand is it's very tricky, this space around giving people advice and making sure it's accurate because things are rapidly changing. The second thing you need to understand in the Canadian context is we're going into an election. We don't know when, we know it's happening. Immigration is one of those areas that rapidly changes depending on the appetite of the public and the parties and our politicians. So whereas other pieces of law are not necessarily impacted by political change, like criminal law is generally relatively stable, family law relatively stable, immigration law is never stable. It changes with political winds. And so the other thing is everything we told you today could potentially be different in a month, right? Which kind of sucks, right? One thing that we know is processing is likely to become longer. Pathways to permanent residence are probably going to become harder. And we're going to see a number of people remain in Canada without status. So we, as groups of people who work with these communities, have to think about that piece.
Thank you so much, Shalini. And I think with that, I know maybe it's not the most neat and tied up bow, I think, to end on. But yes, I think it's clear that a lot of questions remain. And given the nature of the work and shifting policies and times. But I wanted to thank you both, Shalini, Atulya, for your comprehensive, clear, and very thoughtful presentation, and also for willing to be on the hot seat to answer all the different types of questions that attendees brought forward. You're very quick on your feet. It's very impressive. I think the need for these types of sessions is very clear, particularly as we sift through the many new changes of our immigration and refugee system. A short survey will be launched as you exit Zoom for attendees. Your survey responses will definitely help us plan for next sessions and make sure that they're relevant to you. And it sounds like folks have a lot of remaining questions. So please fill out that survey and let us know what would be the most useful for you in the future going forward. Thank you to all of our participants for being present and engaged, for all of your questions, all of your comments. And thank you to our interpreters, Francine, Rana, Mercedes, and Claudia. Thank you, everyone. Have a nice day.
Thank you all.